Welcome to Global Investment Voice, your premier podcast for diving deep into the world of investment migration. Are you dreaming of a second or third passport? Then join us as we traverse the globe, exploring the ins and outs of the U.S. EB-5 immigrant investor visa, uncover the secrets of golden visas, and delve into the many residency and citizenship by investment programs. Each episode is packed with exclusive insights from top industry experts. Whether you're an investor, developer, or a visionary entrepreneur, we're here to guide you through the complexities of global investment migration. And who better to navigate this journey with than your hosts, the dynamic legal duo of this industry, Mona Shah and Rebecca Singh. Plus, hear directly from a lineup of global investment migration leaders. So, buckle up and tune in to Global Investment Voice, where your global investment journey begins and expands.
Hello, everyone. Imagine you're an investor who spent months planning your American dream through the EB-5 program. You've selected your project, you've marshaled your funds, you've prepared the mountains of documentation that's required, and then suddenly, January 21st, 2026, the rules change overnight for nationals of 75 countries. Yep, that's exactly what happened. So on Global Investment Voice, we say it as it is. And if it's not Rebecca with me, it's another wonderful guest who also likes to say it as it is. I'm delighted to welcome back Jill Jones. Hi, Jill.
Hello, Mona. Thank you for having me on.
Thank you. Well, Jill, you're still General Counsel of the Institutional Client Services USA for the JTC Group?
That's right, I am. I'm focusing more and more of my time these days on EB-5 and specialty fund opportunities.
Wow. Well, that sounds very interesting and exciting. And knowing all that is going on with the world right now, you never have a dull moment.
That's putting it mildly.
Yeah. So my opening, that's exactly what's happening, right? We have clients who have been waiting for years, getting everything right. They're almost there. And then suddenly there is another executive order from the president now pausing immigrant visa processing, immigrant, not non-immigrant, for 75 countries. And this almost is effective immediately because it came in effect, I believe he signed it on the 14th and it came in effect like on the 21st.
That's right. No time to pivot at all.
Right. And it includes many countries that would not normally be included, including countries which he has included before, like countries from the Middle East, Kazakhstan and the Caribbean, Pakistan and Bangladesh, Nigeria, Russia, Iran, we always expected.
That's right, Mona. So when we look at the list of the 75 countries, at first glance, it is quite in-depth. As we break it down, though, I think that the list itself causes more panic than possibly necessary. And as we've seen over the history of EB-5, this is the kind of thing that gets everyone stirred up and ultimately ends up encouraging more activity in EB-5. So I'm glad that you and I are able to talk about it today and give some people some reassuring messages, if that's at all possible anyway.
We'll try. But there is a critical distinction, which from another travel ban. Number one, it is not an absolute travel ban. It is a pause. Number two, the suspension only affects immigrant visas. So obviously, working in EB-5, it totally affects our clients, but it doesn't affect anybody who's a tourist, a student, anybody coming in to see FIFA, see the football.
And what it also doesn't affect, Mona, is people that are currently in the United States. This only affects people that are currently outside of the United States looking to come in.
Right. And here's the other issue, which is totally mind-boggling. The whole point of this pause is so that the government, through the consulate, can really see what client coming into the United States might be a public charge in the future. First of all, I'll ask you, Jill, what is a public charge?
Great question. So a public charge is a category of people that may come into the United States and be dependent upon our programs for assistance, such as welfare, food stamps, things that might be viewed as a drain on the assistance that we have here for our citizens.
Right. But so that's why this is so mind-boggling that investors in EB-5 are being affected. And I was asked the other day in one of our IIUSA public policy meetings, I believe it was that, or one of the meetings that we had, whether or not it is actually happening. And it actually is. We have a client, Jill, who is more worried about coming into the US and paying taxes because he's pretty wealthy. And suddenly he gets a denial or on this whole issue that he might be a public charge in the US. It's like, it's crazy. If this man is going to be a public charge, then we need to completely look at the definition of public charge.
Fascinating, Mona, because as we think about the demographic of people who are trying to utilize the EB-5 program, first and foremost, they need to have some sort of wealth. They've got to have enough wealth that they could invest $800,000 or even $1,050,000 into these projects and still have money to live on. So
Right.
how could this group of people be considered a public charge?
And in the whole list, they've also included all of these citizenship by investment countries. Well, not all, but a lot of them. And in order to be a citizenship by investment, you have to have money and extra money to go out and buy extra passports. So it really makes absolutely no sense to me. And I really don't understand the rationale behind it. Do you?
I don't. As you said, we're seeing this list of Caribbean countries is the one that stood out to me, where there's a long history of EB-5 potential investors not having the time to go through the program and finding a faster route into the U.S. by using these citizenship by investment programs and coming in on a different type of visa to allow their children to get an education or to begin a job that they were hoping to begin. It seems strange that that would now be on a list of countries that we want to prevent from entering the country.
Right. And of course, you deal with a lot of high net worth individuals, same as us. And it is obviously something that is still causing a panic, even just because of the time and the effort when you plan that you're going to move into another country. And it's not easy, especially if you have a family. You have to time everything with the children going to school and jobs and where you're going to live. And then suddenly you get thrown with this. It's a total disruption.
It is. And if there's anything you and I have learned in EB-5 is anytime there's a disruption, there's a panic.
Yeah.
And what investors in EB-5 are looking for, they're hungry for, is certainty.
Right. Well, it is different. I'm going to ask you, look, we compare it to the Trump 1.0 travel bans, which were immediately attacked by the courts, by the way. And they've been smart here because it's not a travel ban that they can go and rush to court with. It's a pause. And it's a temporary pause, but we have no idea what the word temporary means here. Does temporary mean 3 years, 3 months, 3 days?
Well, I think that's a good point because without knowing how long this pause would be, I would encourage people to still continue in the process. If it is ultimately a few months here or there, it would behoove the potential investors to continue the process and be ready once that pause is lifted.
So for our client, we're immediately attacking it. We're filing a motion with the consulate and we're just going head on and challenging this denial because it's just nonsense as far as this candidate is concerned. And quite frankly, for most EB-5 projects, unless you do your own project, if you go into a regional center, you need to be an accredited investor anyway. And that means you have a certain net worth, which would mean that you wouldn't be anywhere near candidacy for a public charge.
That's absolutely correct. So I'm curious, Mona, how did USCIS get to the point of denial when this is only supposed to be a pause, not a denial? Were there other factors?
It wasn't USCIS. It was the consulate. We feel that they haven't looked at anything. This was at the moment, the consulate is so backlogged. There's things pending forever. I feel that what the consulate just did was just see which countries are on the list and then issue a blanket denial because the actual denial is very generic. It doesn't have a date. It doesn't have a real reason. It just quotes the executive order and that's it. So that's what it seems to me. And that's why, as I said, our first issue is that if you're facing this, we challenge it straight away. But alternatively, for people who are very nervous and there are other routes, I suppose, right? Outside of the gold card, which we're not discussing right now, but which is certainly picked up and we'll discuss in the future. But what other routes could somebody take if they really didn't want to go into being challenged or challenging rather the consulate?
Well, I think we start right where we were a moment ago with our citizenship by investment in other countries and using the E-2 treaty to come into the country. That would not be an immigrant visa. That would be more of an employment or an opportunity visa.
Yeah, but the only problem with that is the fact that under Biden that there wasn't an immediate connection for people who have suddenly obtained citizenship by investment, say, for example, in the Caribbean, like, say, Grenada. They have to now show residency for 3 years. That really isn't an immediate help, Jill.
Well, again, though, it is a certain path. And if someone does have that 3 years to go, then it would certainly be something they would look into. But if you do have a situation where an investor has made plans, they have housing lined up, they have employment lined up in schools, you're right, that would not be the best choice. So I'm curious, are you advising your clients on any other routes?
Well, again, there are certain category who are really seriously looking at the gold card, but alternatively, there's always the non-immigrant processing that they could use if they are under a treaty country and they can do an E-2. So the E-2 is there. We look and see if any other business visas available for them, like an L1. But even if they come in on a B1, B2, that is a possibility. I've heard other lawyers discuss this, that they've asked their clients to come in on a B1, B2, stay in the country for a few months, and then file for an adjustment within the country.
Do you think there is a risk to doing that in terms of changing your intended path?
There's always a risk under this administration. It's more for those who really want to be in or desperately have to be into the country, and they're ready to take that chance. But there are many people under the EB-5 who do take advantage of the concurrent filing, by the way, who do this, who come in on a B1, B2, stay in the country for over 90 days, and then file for their adjustment.
You know, that's a great point, Mona. One thing that I have noticed recently, and I would say in terms of timing since the Reform and Integrity Act was enacted, we're seeing more and more groups that are marketing these EB-5 projects here in the United States. At the time, I think one of the pieces of certainty they were working around was H-1B concerns. If someone were working for a company in the tech industry and that company were to file for bankruptcy or have an employment reduction and these people were left without a job, that's a very uncertain situation to be in. So marketing to H-1B holders has become very much more popular in EB-5 regional centers and issuers.
That's true. The market within the US is actually as much as the market outside of the US. And don't forget, our colleagues in the global market are really jumping on all of this stuff, saying, are you sure you really want to go into the US? You know, sometimes I say to the clients, would you really want to come to the US? But many people come for other reasons as well, Jill. You know, like their company sponsors them, or they really do see that there is work opportunities, business opportunities. But it's not always, they don't always need a green card. They don't always need the EB-5. I mean, obviously, there is a certainty, because here's the other thing. You know as well that if you come in on an E-2 and if you're here on an E-2 for many years, you're not really in a situation where you can go out and get loans, a lot of SBA loans and things like that. And now Donald Trump has changed that. You can't get certain loans at all unless you are a permanent resident and a US citizen. Yeah, it makes a difference if you want to do business in the US.
It certainly does. I think the question from the very get-go is, do you have a long-term intention to be in the United States? Or more accurately, do you have a long-term need to be in the United States? Your intentions when you're starting this process can really change the way that you plot your course.
Yeah. So you work mostly with the bigger regional centers, Jill, right? You don't work with the smaller ones?
Well, actually, we work with all sizes. I would say it's a very different experience when we're working with a large established regional center versus a first timer. The main difference would be how much work on the front end goes into giving examples of what we've seen work in the past, or encouraging people not to do certain things that we've seen be disallowed.
So you help a lot more with the flow of money.
Oh, absolutely. The way
Yeah.
JTC and previously as we were known as NES Financial, our very first foray into EB-5 was helping people bring the money into the country, finding banks willing to accept it and hold it without having a relationship with the foreign nationals.
Yeah. Well, I know you deal with many, many different projects and regional centers. And let me ask you, even despite all of what's going on, are you seeing a slowdown, even with the whole pause issue?
I'm not. And I think we have competing issues going on here. The one big elephant in the room is September 30th of 2026 is an end date to a grandfathering protection that was
Right.
established in the Reform and Integrity Act. And because of that, leaving an uncertainty after this coming September, there's an absolute tailwind for investors to come in right now where they know that they will be adjudicated under the laws that are in place today.
Yes, but that's for the regional center program, not necessarily for the EB-5 program, because that's already enshrined in law. That's part of the fifth employment-based category.
You're absolutely right, Mona. And I think a lot of people forget that point. I think the reason they forget it is because the vast majority of projects are put together under the regional center program.
Yeah.
But we have seen in the past when the regional center program has sunset for a period of time, those direct EB-5 investment opportunities do come about. They just don't have the glamour or the track record of success.
True, but here's the other thing also, Jill. They are harder in some ways. Yes, you have control of your business, and we will talk about this, I know, in future podcasts, but 10 permanent, actual physical jobs is not always as easy as you think. It's not like a regional center where, the jobs are indirect and you build a building, your construction jobs are there. The actual non-regional center projects, they really rely on physical W-2s and people. And how many times have we seen that a franchise doesn't really need 10? It can work as efficiently with 4 people or 5 people.
Yeah, you're absolutely right. When we look at the typical project size of a direct investment, we see things that are franchises, as you just mentioned, whether that be in the hospitality industry, maybe a restaurant franchise, even in medical. We've seen medical office buildings be franchised out. Dental is a big one. And when we look at the number of employees inside those businesses, it's not as many. And so it is a bigger challenge to make sure that it fits with the job creation component of EB-5.
Right. And again, if something like this happens and if it's your own franchise and you're actually getting ready to come into the country and suddenly there's this big pause, that's a problem. Who's going to look after it? So yeah, there's so many issues. There's so many points that we can discuss and we can keep on discussing. Jill, I'm sure you'll be back. Let's see how this pause goes. Let's get some feedback and see what people are actually doing and, relay it to our listeners.
I think that's a great idea. And if I had one piece of parting advice, I would say don't panic. And
Absolutely.
I would say to investors on the list of 75 countries, don't stop. Keep going. This will right itself and it will work out.
What great advice, Jill. Thank you.
Thank you, Mona. It's always a pleasure.
And that's a wrap on today's episode of Global Investment Voice. A huge thank you to all our listeners for tuning in and sharing this journey with us. Curious about unlocking the potential of global migration and citizenship? Make sure to visit us online at mshawlaw.com and globalinvestmentvoice.com. Dive into our extensive library of podcast episodes. Stay ahead with the latest in migration news by signing up for our insider newsletter. Don't forget to connect with us on social media. Find us on LinkedIn, Instagram, and Facebook to keep the conversation going. Remember, the insights shared in our podcast are for informational purposes only, so please seek tailored legal, financial, or investment advice where needed. Thanks again for listening, and until next time, keep investing smart and living well with Global Investment Voice. We'll see you on the next episode.